me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Just speak low, stand in your row, try not to show this life's a show. Try not to glow way down below. Oh, it's a lot of woe, and that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you not to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true,
Hey, I'm sorry, you guys. It's not, I don't have control over it. It's Streamlabs. There's nothing wrong with my internet. It's, I'm gonna have to tell them because I'm getting kind of tired of them doing this to me. Stop dumping my stream. It's rude. We're in the middle of a trial. I don't have time for this shenanigans. Sorry, you guys. I don't know what causes Streamlabs to lose connection with YouTube. I don't have any control over that business. But don't you guys worry. I have it stopped where it stopped. So you guys don't have to worry about that. I got it like all we're ready to go. It just makes me mad because like there's like a ton of, there's a ton of people covering this trial, and I hate it when you guys come in here and we're on a good roll. We're having like the testimony is, flowing. We're, having fun together in the chat, and then it freaking dumps the stream, and then you guys are just thrown wherever, and then you got to, sometimes it'll notify you that I'm back live, sometimes it won't, and it makes me mad. And I still stand by what I said. Miss Nestor, your freaking your jacket on Friday looked like Blanche Devereaux's bread spread. No regrets. I said it. I meant it. I stand on it. This Donna is Allison Wright. Obviously, you can read it on your screen. She's her husband and Eric Richins were in business together. They owned the masonry business together. So, that's That's who she is. All right, you guys ready to start this up again? Hold on, we could probably do better. It's added. All right, here we go. I don't like it when that happens. Makes me so mad. All right, here we go.
Sustained.
All right. Setting aside your personal financial affairs, you're very aware of C&E's financial affairs, correct? Because you do the bookkeeping.
Correct.
All right. And
Objection, Your Honor, this is still outside the scope.
no, it's not.
Yeah. Please approach. I'm not sure where you're headed here.
Objection, Your Honor. This is still out of beyond the scope. No, it's not. I'm getting. No, it's not. Is not a legitimate legal argument. You can say, no, it's not because or Your Honor, may we approach? But no, it's not is not an acceptable legal argument.
Your next question, please, Ms. Nestor.
Since Eric's death, you and your family have grown pretty close to the Richins family. Is that fair?
Objection, Your Honor.
Goes to
Outside the
bias.
scope.
Goes to bias.
Overruled. If you would please restate the question.
Since Eric's death, you and Cody have become very close to the Richins family. Is that fair?
I would say the relationship didn't change.
So you were very close to them before.
Yes.
All right. And it's true that since Eric's death, your husband has even accompanied them to court hearings and sat beside them. Is that right?
Yes.
All right. Have you?
Yes.
And I think everything else is going to be when we recall. Ma'am, we're going to recall you later, and we would ask that you're not released from your subpoena, and the judge will instruct you about that. That's all we have at this time, Your Honor.
Okay. Anything within the scope of cross, Ms. Shernick?
If I could just have a minute.
Of course.
No, Your Honor.
Okay. Ms. Wright, you're free to go today. You're still subject to the subpoena that you were served with. You may be called back. Between now and then, please do not speak to anybody about your testimony, including your husband, okay? And please don't watch any coverage of this case. Don't read, listen, watch anything about it. Do you agree to do those things?
Yes.
Very good. You're free to go. Thank you for your time.
Thank you.
Good time for a lunch break, counsel? Or do we have another short witness you want to get on and off?
Your Honor, we can break. I understand there's some legal issues to address too, so.
Understood? Okay. Any objection to a lunch break, counsel? All right, please rise for the jury. Folks, quick reminder, you know what I'm going to say. Please don't discuss the case. Don't read, watch, or listen to anything about it. Please don't do any research. Enjoy your lunch. 12:40, counsel, is that reasonable?
Yes, sir.
Yes, sir.
Okay, 12:40. Thank you. Have a seat. Thank you. We're on the record. Mr. Blake.
Your Honor, we're going to quickly next call Detective O'Driscoll just for a phone download. He'll have perhaps more time later.
Okay.
But then it's Mr. Cochadimos, and I understand the defense has some objections related to Mr. Cochadimos.
Mr. Ramos, tell me more.
Thank you, Judge. I figured we'd do this just outside, that way we can speed things along. We've been provided with some exhibits that appear to rely, and correct me if I'm wrong, on some CDR data, call detail records, from Verizon and T-Mobile, I believe, and AT&T. Those items, we were not provided notice of their use under 901.11, and so we would just make an objection under that.
Forgive me. They were provided some reasonable time after being received by the state.
Yeah, no, the information was provided to us. We've had that for a while, just notice of their use under that business record exception.
Can you give me that citation one more time?
Yeah. Apologies. Rule 902.11, I believe is what we would be coming in through. And specifically, I'm referring to the written notice.
Why isn't inclusion of these records on the state's exhibit list fair notice under 902.11?
Just based on the case law, Judge, I could give you a citation. I have two cases I think are fairly on point. 32P3D 976, State v. Webster.
What's the other one?
And then 322 P3D 624, State v. Pereira. We just bring this up, Judge, now. We could have a ruling after lunch is fine. And that would be our only objection.
Okay.
Thank you, Judge.
Mr. Bloodworth, I made an assumption there, if you could just confirm it for me. These call detail records were in fact included among the state's proposed exhibits on its exhibit list?
Yes, Your Honor.
Okay. Anything further on this, sir?
Yeah, right, Your Honor. Just to clarify that, they've been disclosed, and the disclosure included the certification
Right.
from whoever returned the subpoena.
Right. The declaration. I understand your point to be slightly different than the self-authenticating piece. Got it?
Correct.
Okay. Pause there for a minute. I'll take a look at those two cases, Mr. Ramos. We can pick this up at 12:40. After Ms. Crosswhite testified, and after we took that break, one of the jurors passed out the following note. I'll read it. I don't think this is an issue, but
Oh
just letting you
my, a
know.
note from the juror.
Quote, Judge, I have met witness Molly Crosswhite professionally. She has done one transaction for a home where I work. Any concerns, Mr. Bloodworth?
No, Your Honor.
Oh, there's going to be an issue. They're going to try to make it an issue. Hey, Jen's a gypsy. Good to see you. Welcome in. They're gonna try to make this a thing. Let's see what happens.
My to-do list.
Sure.
Either following lunch or at the end of the day, may we address the motion for mistrial that you made at sidebar following the mention of jail calls by Ms. Gibson?
Yes, sir, I'm prepared whenever you are.
All
Just
right.
let me know.
Let's do that after lunch as well.
Okay.
Thank you. We will be in recess until 12:40. Thank you.
All right. So they will be in recess until 12:40, which means we will be in recess until 12:40. Uh, hold on a second, because I have something for you guys that I think will get us through the lunch hour. So, you guys are familiar. If you're not, let me know. Um, with the what's been called the walk the dog letter. If you're not, let me know, because um, there was a hearing, and I'll tell you exactly when that was. Hold on. Let me see. It was this hearing took place January 24th, 2025, in which the controversial walk the dog letter is being discussed, and essentially they want it suppressed, and obviously the state does not want it to be suppressed. So I thought, um what if we talk about, what if we watch all of that surrounded it, including there is a video from the video surveillance of just exactly how all of this, how they found this quote unquote walk the dog letter. Let me do something really quick for my own purposes, so that I don't want us to run too far um, over into lunch. And are you talking about the witness that was up there? If you are, Kelly, I think it's because she was incredibly nervous. See, um, and I think I don't think I fully appreciated this, um, as to like, I don't think I have fully appreciated the weight of the criminal trial and the civil trial as it relates to certain witnesses in the criminal trial. It's my understanding that the civil trial was put on hold while the criminal trial took place. And Judge Moratz Morans is presiding over both the criminal and the civil trial. And I think that there are some overlapping witnesses to both trials. And I think part of the reason why that particular witness was nervous is because it's probably a few things. One, the trial's being streamed, so it's in front of God and everybody, right? Not just a regular courtroom, which is intimidating enough. But I think it further complicates the issue because sh her husband and Eric Richins were friends, and then they were business owners together. They owned that Mason company, the stone company together. And masonry, not masony, masonry company. I don't know what I said. I'm sick. I don't remember anyway. So they own that company together. And I think it's messed up when you're that close to somebody. They went on vacations as families, they went on vacations separately, couples vacations, etc. And then you find out that somebody that you were hanging out with, somebody that you were close to, you know, you vacation together, you hung out together, whatnot, and they freaking are on trial and accused of murdering their husband. Like, it's messed up. And then, and you knew both of them. It's not like she just knew Kouri or she just knew Eric. She knew both of them. So I think there's that element to it. And yeah, it's messed up. Oh yeah, yeah. Sarah. Sarah said Corey's face was giving if looks could kill vibes. Yeah. Yeah. Like Kouri has zero poker face. I know she thinks that she is good at giving no face, and I know she's trying to not give a face, but spoiler alert, ho, you given a face, just so you know. But let's listen to this about how the walk the dog letter was discovered and why it's coming, what the judge I don't know if he decides in this one or not because I haven't watched this all the way, but let me push play and let's get to it. All right, here we go, because it's a longer, I'm going to speed it up though and turn on closed captions because hold on, where's it at? What are you doing, Jen? Right here. Just because I want us to be able to hear it, but also like we don't have that much time because they'll be back from lunch here in a little bit. But I'm keeping an eye, so we're not going to miss anything. All right, here we go.
So, could you tell me what initially led to the search at that time?
Do you have a specific search?
Yes, let's start with, I believe there was a search of Ms. Richins' cell on September 13th of 2023.
Okay. So Ms. Richins had a medical episode, and so there was a brief search initially after medical had treated her. And that was a quick search to look for any obvious contraband left over from EMS personnel. And then shortly after that, there was indication that there was possibly something held up on a video chat.
Okay, I'm going to ask you about that, but let me just take it one step at a time. So initially, she was taken out of the jail for a medical situation.
Yep.
And there was a search on September 13th, and all you were looking for was if anything was left behind by the EMTs, is that correct?
Initially, yes.
Okay. And then when was it you became aware of a video call that led you to want to search the cell further?
So it was while she was away from the jail that was brought to my attention that there was possibly something held up in a video chat. So we searched the cell looking for a piece of paper with cursive handwriting on it.
And that search took place on September 14th, is that correct?
13th, I believe, is my dates.
So, all right, so the first search on September 13th, you
Correct.
didn't seize anything from her cell at that time, is that correct?
No.
And you believe the second search was September 13th?
So there was an initial search of just immediately nothing to do with any case. It was just a contraband search of any medical items left over in that immediate area. And then while she was away, there was a indication that there was possible issues with a video conversation where she held up a piece of paper.
And on that occasion, did you search just her cell, or did you search the entire pod?
It was just her cell in that one.
All right, and that was also September 13th?
Yes.
And nothing was collected on that search either, correct?
Nope.
So what led to the search on September 14th of the pod and Ms. Richins' cell?
So there was random cell searches of two different sections, Golf Pod and Bravo Pod. And then also with her medical condition, she was going to be moved to a different cell for observation.
All right. Alex, can you just put on, I'm going to show you some videos of the search on September 14th. We'll try not to go through every single one of them. Could you start pulling up? It's States Exhibit 69, but it's number 8 on our list. And before we start that, well, actually, no, go ahead. Let's put that on, Alex. Thank you.
Your Honor, can I just offer the court some context? The video system, because it's so data heavy.
Ask him about it, but
Oh, okay.
I'll ask him.
That's fine.
That's fine. Okay, yeah, just don't, you pause it for now. Let me just. So before we start, can you tell me, is that you in the video there?
Yes.
And which of those cells belongs to Ms. Richins?
I believe at this time Ms. Richins was in 4, which is upstairs.
In fact, it's the top right cell, is that correct?
Correct, yeah.
That one that is being pointed to on screen? All right. And the video camera where's that video camera?
It's elevated. It's on the back wall.
Is that the only camera in that pod?
It is, yes.
And
Next to an observation cell, it's in cell 5.
where's that at? Can you,
It is the bottom left corner.
that we can see? Or,
It's-
left corner over there?
Yeah, so that'll be just directly in the cell. It won't view anything else.
All right. So who runs the video camera?
What do you mean?
Is there someone in charge?
It's It's like an ongoing thing. Observation cells can be turned on and off.
Is the video camera run all the time or just?
The main section cell, yes.
All right. And that video camera, as we're going to see in these videos, it freezes a lot. Is that correct?
I believe it is a motion-based.
You believe it's emotion based?
Yes.
So if it's not,
If there's no movement, I don't believe it records until it senses movement.
all right, we'll talk about that as we look where some of it is where nothing is moving. Who is it that collects the videos from that camera?
I believe it is our administrative sergeant,
Who is that?
Sergeant Thomas.
Okay. And is he the one that would have provided the videos that we have in evidence at this time?
He'd probably be one of them.
Okay. Alex, you just play that video. Now, these videos, I think each is about 1:30, but it's an ongoing search, right? They happen one right after the other. And
is this of the 13th?
I believe this is the 14th.
Okay.
I believe. If I'm wrong, please correct me. Let me ask you while we're looking at this. So the stuff that's on the tables downstairs, is that stuff that's been taken out of cells, or is that stuff that was just left by inmates?
Without knowing exactly what date of this search, I can't see the date, but that looks like it's indicative of somebody being in the day room, inmate-wise, and then being either locked down or moved abruptly.
Your Honor, if I may.
One moment. Okay.
You can't see it, but if you were to shrink the video, the date and time are in the top left corner.
right?
This is the video of the 14th, and the time and date stamp are on the video.
Remind me the exhibit number for this one.
This is State's Exhibit 69. All right. So go ahead, Alex. In the video there, you've just entered Ms. Richins' cell. Is that correct?
That appears to be me, yes.
And she doesn't share that cell with anyone, or she didn't, correct? She was there alone. So what is it you're doing here?
I would be looking, if this was on the 14th, this would be doing a search and then also gathering up her belongings and moving it down to cell 5.
Oh, that's okay, because she was moving to cell 5.
Correct.
All right. Now, this was after you had already searched for handwritten notes the day before.
Yes, the cursive letter.
Okay. All right, Alex, it's okay. Let's go on to the next video, which is State's Exhibit 70. That's number 9. I'm just going in order. Can you zoom in a bit, Alex, on the cell so we can maybe see better what's... It's a little bit difficult, but... Okay, there we go. So what is it that you are... All right, there, in your hand, it looks like you have an envelope?
Correct.
And is that an envelope that you had looked at the day prior?
I observed it, yes.
But you didn't look in it
Nope,
that day?
not looking at it, nope.
Now, is this the envelope that on the front has Ms. Richins' prior attorney's name?
I believe that would be the one.
Okay. And it says attorney privileged or something to that
I don't recall it
effect.
saying that. I just recall it saying Sky Lazaro, who I knew was her attorney at the time.
All right. And if a report indicated it said attorney privileged, do you have any reason to disagree with that?
I didn't see that, so...
You don't recall?
I don't recall seeing that on there. But
Okay. So on this search, you opened that envelope, correct?
Yes.
And go ahead, Alex, you can just play it out well. And what was it you found in that envelope?
In inspecting that envelope, there was numerous paperwork. There was obvious court heading, court minutes. There was some, what appeared to be like some cards that were made from children. I didn't observe any obvious other contraband.
There were handwritten notes in that envelope,
Yes.
correct? Quite a few, isn't it?
Yeah.
Accurate, there were a lot of handwritten notes. And you looked through those notes that day?
Yes.
Oh, I'm sorry. I know I'm bad at that. I'll try harder. All right, let's just go to Exhibit 71, Alex, number 10.
So JL says, thanks, Jen Lou. I was getting confused, and that's why the defense is pissed about jail calls then, right? Because then the jury knows she's locked up. Yes. I'm guessing, I'm not an attorney, but I don't know. I guess I could look. I'll look when we get back from lunch. I don't know if it's something that they stipulated to in this trial, that the jury was not allowed to know that she was in jail awaiting trial, or if it's part of Utah criminal code that she's not, that the jury, that they don't mention that to jury. So I'm not sure which one it is, but I'll find out for you guys. And so I just wanted you guys, they're not back from lunch yet. I'm watching on the other screen. I just wanted you guys to be able to see this, because this is an important piece of evidence. because it comes out while she's in jail, obviously. It's a big deal because the letter, is her instructing a witness. And if I am not mistaken, this is, I think that this resulted in an allegation of witness intimidation. And there was a hearing with her previous attorneys about this witness intimidation. And basically, what they were saying is that this it's prejudicial. It's prejudiced the jury pool at that time because the letter came out publicly, and apparently was some articles that come from what the defense said is clearly the state or the prosecution somewhere in there. And that the issue at hand is that the state is basically saying because she wrote this letter and tried to get a witness to say to lie or whatever, that therefore that makes her guilty of murder. And I'll tell you exactly what the judge decided with the walk the dog letter, what the ruling was. Eventually, I'm sure they need better quality video.
Can you tell me who the other 2 individuals are who are coming towards the cell at this point?
That is Deputy Watts, and that is Sergeant Thomas in the bottom, and then the one in the white shirt is our nurse.
All right. Now, were you still going through the...
Oh, and I forgot another part too. They're back. Hold on. They're going to argue about the mistrial or something, a couple of things. But so I'm going to put this on. The other issue with what the defense said with the walk the dog letter is that it was clearly they shouldn't have even opened it. It was part of attorney-client mail, and therefore violates her one of the amendments about that talks about having counsel and it being between you and the counsel. All right, so here we go. They're back from lunch.
The defendant's objection regarding the call detail records that I understand Mr. Kontradimos is going to testify regarding. Is that correct, Mr. Vliver? Ms. Shervnek?
That's my understanding.
Kontradimos is the gentleman that they'll come in through.
I'm not going to be seeking to admit the call detail records.
I'm confused.
I imagine they were used for some of their demonstrative exhibits.
He relied on call detail records to create some of our exhibits.
Got it. Good enough.
But I'm seeking to admit the visual representation of those call detail records that he helped create, that he'll testify came from the call detail records, although the call detail records themselves, the state is not seeking to admit as an exhibit.
Got it. Okay. I've looked.
You guys are right in the chat. Neat says that letter was not addressed to her attorney. Ivy Lee says, yeah, but they were sent to someone else. That is correct. I think it's a weak argument, but that was the argument that was made nonetheless. All right, here we go.
At the Webster case, it certainly talks about notice with respect to Rule 807, which has a notice provision, and case law talking about how that notice provision works. The Webster case doesn't mention 902 at all. I'm not sure I was following your argument, Mr. Ramos.
Judge, the 902, 803 rules and those identified in the residual exception in Webster, they reference the same language, which is the notice language. That's what we were focusing on. I think Your Honor has enough to make a ruling.
Okay.
I understand your position.
Got it.
Yep.
All right, so under Rule 902, subsection 11, records that can be self-authenticating under that rule, before the trial or hearing, the proponent, in this case the state, must give an adverse party reasonable written notice of the intent to offer the record and must make the record and certification that makes the record self-authenticating available for inspection so that the other party, in this case defendant, has a fair opportunity to challenge them. All of those things have occurred. The call detail records and the certifications under Rule 902 that are included with them from the mobile service providers have been made available to defendant for inspection through the discovery process, and by virtue of the fact that those records have been part of, or at least the portions of those records that the state seeks to publish to the jury have been part of the state's exhibit list, the state has given the adverse party reasonable written notice of the intent to offer the record. The court finds that defendant has had a fair opportunity to challenge those records. Any objection to the admission of that call detail record information under 902.11 is respectfully overruled. Anything further, Mr. Ramos?
No, Judge. There will be through Mr. Kocher-Bemis some testimony regarding the .png files or the GIFs. I would, at that point, probably ask to hear the witness, assuming they're going to be asked to be introduced to evidence. So I just let the court know now and get sure of that.
Which file type was that?
They're like GIFs. They're those GIFs that were presented during the
Oh, the pathways that link to those.
Correct.
Oh, I love that gifts are coming in. JL says, Jesus, Jen Lou, you can't be popping off with nonetheless. Sarah Boone triggers, my love. Please, I'm a stroke survivor. I could die, Jen. Be careful. I appreciate that. I will be more careful in the future. However, I would like to say this. Sarah Boone overused the term nonetheless, and that is why it's triggering. And I guess I have finally, after all this time, moved somewhat past Boone to be able to use that word again. I actually like that word. It's a good word. All right. I wanted to tell you guys about this question that I looked up. So the question I asked is, can a jury know that a defendant was held in jail awaiting trial in Utah? The AI overview is this. Yes, a jury can know that a defendant was held in jail while awaiting trial in Utah, but the court and defense attorney will generally take steps to prevent the jury from learning this information to avoid prejudice. While the fact of detention is a matter of public record via court exchange records, it is not typically disclosed to jury during the trial. Obviously, they do the whole situation with the clothes, the visible restraints, all that, right? That's par for the course. Let's see. I am not sure about how that letter is going to come. Like, I know it's going to come in. I just don't know what they're going to say. So that's the next thing I'm looking up. All right, here we go.
Got it. Okay.
Can I ask just a general question, just to avoid, because I think it's going to come up. So it's my understanding that the extractions have now been put into evidence, correct?
Not the physical documents,
But
of
the-
the extraction, but the testimony about who extracted or downloaded the phones. Yes.
And we've put the phones in, but we have not put in the actual, we've not put in the report, the data that's been fed into the Celebrate software platform. Is that in?
The raw data is not readable.
I know. The raw data is in through the phone, but is the Celebrate data that has been extracted by Ingtao, was that put in?
Not yet.
Okay, so if that's not in, how do we have from Coaster Demos, how can he put in the demonstratives that are based on that? Because it's just basically a different, it just makes it into a picture, but it's the data from what's not in yet.
So you have witnesses talking about the physical device containing electronically stored information was secured.
Correct.
You have testimony creating a chain of custody to the people that downloaded it through a two-step process.
Right.
The gray key,
Right.
forensically mirrors that phone. And then Cellbrite is how, among other people, I imagine Mr. Katradimos would say, I was able to read and process and parse out, quote unquote, that information. Not everything on that phone is relevant, so not all of it goes in. We're going to see what parts the state believes are relevant through Mr. Katradimos. He hasn't testified yet.
So he's going to be allowed to testify what's the information that's in something that hasn't been put in yet. Because without putting in the extraction,
There is
it's
no
not
basis
readable.
to admit the extraction. There is a lot of information on that phone that I imagine is not relevant under
Sure.
401 or 402.
Agreed.
So there's no basis to put in the entire extraction.
So
It's
this
not
is-
like an
Okay.
encyclopedia.
Well, then this is getting to the core of what my concern is.
Yeah.
And I'm just thinking out loud to try to avoid wasting Coaster Demos's time. But let's say, hypothetically, we want to get some of the extraction information in at a later time.
Do you have an expert that has looked at those extractions with Cellbrite and can testify and lay foundation?
We do.
Okay.
No problem. But my question is whether our expert can do the same thing theirs is doing, which is relying on data they saw in Celebrate and parsing it out without the Celebrate extraction coming in. Because as long as we can do it too, I'm totally fine with this whole process. But what's worrying me is we're going to get to my side and they're going to say the extraction's not in, your expert can't testify. So I guess I just want to make sure we're all on the same page. The extraction doesn't have to come in as long as our expert has reviewed the extraction and they've laid a foundation for authenticity of the extraction, which, by the way, I don't think either side is challenging the authenticity of the extraction ultimately. But the same thing's going to apply when our side gets up and our guy says, this is what I pulled out of Celebrate. I'm going to use this in what we're going to present.
Are you talking to me or them?
I'm talking to you. I just
I'm
wanna
not
make
sure what you're asking for.
I'm asking if we need to have a hearing now about whether the extraction has to be admitted for all this to come in, or if the extraction doesn't have to be admitted, there's no problems.
The only reason we've talked, as I understand it, about the extraction process at all is to lay foundation for the expert testimony of people like Mr. Katradimos.
Perfect. So you will not require for Coaster Demos to testify about the data that he read from the extraction. You are not going to require the extraction to be admitted into evidence. Because if that applies, then that applies to us too, and we're fine with that.
As long as your expert is an expert and doesn't say or do something else objectionable, I don't know who your expert is or what they're going to say, so I need to be a little bit circumspect here. But the fact that a copy of the extraction from Gray Key on a portable hard drive has not been admitted
That's what I'm asking.
as an exhibit is not an impediment to this kind of expert testimony.
That is exactly what I needed to know. Because if it is, we
It's
need to have
not.
a hearing on it, and if it's not, then there's no problem, but I just want to make super clear that we're all on the same page, that it doesn't have to come in for us to pull things out of it and admit it.
Yeah, I think we need to keep in mind the life cycle of these things. There's information gathering, there's chain of custody and information preservation, and then there's what's admissible and how it comes in.
Sure. The only reason it's just unique is because the phone itself, without the extraction, the hard data is not readable, as the witnesses have talked about.
Right.
I mean, like, if the juror was given what was extracted out of the phone, they couldn't do anything with it anyway.
You and I agree.
Okay, I just want to make sure that we don't do that wrong, so that the extraction, the hard drive extraction itself doesn't have to come in, and we can all pull pieces out of it that we want because the foundation's been laid.
Yeah, I want to be careful. You're saying the extraction. There are several.
There are.
I'm familiar with the ones for which foundation has been laid so far. I don't know whether you're talking about some other devices regarding which foundation has not yet been laid.
Eric, Kouri's phone.
This is, again, I feel like you're talking to the state, not me.
No. I think we're all in agreement that the extraction doesn't have to come in. As long as the extraction doesn't have to come in and we can use pieces of it,
He's just,
I'm totally fine.
Provided.
look, here's the deal, ma'am. Again, I need to point out, I'm not an attorney and I only have a GED. Okay? A good enough diploma. And even I understand what the judge is saying. You're asking a very broad question. What he ruled on was very specific. So if you continue to ask the same broad ask question, you're going to get the same answer. If you want to get specific and you want specifics, then ask a specific question so that you can get a specific answer. See, this is what happens when you don't ask the right questions. If you don't ask the right questions, you don't get the right answer. That'd be like me calling up a doctor's office and asking a question about what should I do because Mac the cat has been throwing up. He hasn't. This is just a hypothetical. Why would I call a medical doctor who practices medicine on humans about a question related to an animal? Right? The better place for me to call would be a vet's office. This is ridiculous. She's stressing me out, bro.
Sufficient foundation
Sure,
for the
to show it's
extraction has been laid.
admissible. To show it's admissible under other grounds, 401, 403, hearsay.
Authenticity, yeah.
Well, authenticity is an issue, right?
If you're talking about a device that we haven't talked about yet, you're going to have to lay some foundation.
No. Assume for purposes of this conversation, it's only devices that have been admitted. So
For the purposes of this conversation and putting aside other 702 related objections that the state may make when your expert witness is testifying,
Right.
what's good for the goose is good for the gander
Perfect.
with respect to the extractions.
Perfect. Perfect. That's all I needed. Thank you very much for taking the time. I do think that's really complicated and strange because of the way that the extraction is a different data set than the actual guts of the phone, which is unreadable. So that's why I just wanted to clarify that. So thank you very much.
Okay.
Any more gibberish?
I forgot how that began.
Oh, the juror issue. We got to talk about the juror issue.
We can switch to that. Anything else regarding Mr. Kotradimos before he takes his stand? Ms. Shervanek?
Nothing from the state, Judge.
Mr. Ramos? Okay. The juror note. Go ahead, Ms. Lewis.
Your Honor, we do have some concerns about the note that came out from the juror.
I told
first,
y'all. Hold on. Didn't I tell y'all they were going to have concerns about this juror? And here we are. Let's rewind it so that we can hear everything that she has to say, as much as it's going to probably be annoying.
Concerns about the note that came out from the juror. First, I believe that had we had this information during jury selection, this juror would have been weeded out in the process because they had a business transaction with the witness. So now we have someone on the jury who I think who I believe, based on our parameters, wouldn't have even made it to the final pool, so that's concerning. The other concern is we don't know anything about the interaction with Ms. Miss Cross-White, positive, negative. I did have to push back a little. That concerns me a little bit that, if he thinks very highly of her, that could be some bias, that I did have to get up and push back. And our position would be, out of an abundance of caution, we dismiss that particular juror.
Are you prepared to address this now, Mr. Bloodworth, or do you need some time to think about it?
Your Honor, we can address this now.
I want to be transparent. I'm not going to rule in this moment. I will need to just take a look at what legal standards, if any, there are regarding this. But if there's anything you want to put on the record now.
Can I just add, I'm sorry,
Yeah.
Brad, it is our understanding that Ms. Crosswhite went by a different name, so I'm not implying this juror intentionally withheld information. He may have known her by a different name.
Understood. Go ahead, Mr. Bloodworth.
Your Honor, I don't know that the jury note provides the court with sufficient information to make a determination at this point. It seems to the state that a little bit of voir dire would probably benefit the court, but based on what the information the note contains, I don't see cause to strike or dismiss this juror.
All right. Ms. Lewis, my sense of this is I don't need to rule on this right now. I can give it some thought. There's no harm in leaving the juror right where they are for the time being.
Agreed.
Okay. I won't lose track of this. Let me think about it for a minute. It may be that I just need to ask this person a few questions, and then we'll go from there. Okay. Motion for mistrial, Ms. Nestor?
Sure. Just really briefly. As the court will recall, during the time that I had Ms. Chelsea Gibson on cross, I was trying to lay a foundation to later get in some of the home wave calls that had been downloaded. According to her reports that we were provided, she was the individual who downloaded all of them and stored them into evidence. And I believed that I had to at least lay a foundation of authenticity if I later wanted to admit those calls. So I was trying to do that. I was trying to do it very carefully. I warned her to please copy my language. I looked right at her. I used very specific language, and her response was, "You mean the jail calls?" I understand things like this happen in trial. But the case law that's relevant, I believe, it implicates Ms. Richins' Sixth Amendment right to a fair trial. It affects the presumption of innocence because if the jury is aware that she's been incarcerated, there's been case law that says that can impact your presumption of innocence. There is a pretty recent case in Utah, State versus Bernejo, Bernejo. The site is 476 P. 3rd 148, which acknowledges that evidence of custody status can carry the risk of prejudice. I will absolutely concede all the case law gives you so much discretion in this area because every circumstance is different, every situation is different. They really, really do rely on the trial court judge to make a call in the moment. Now we have this situation through no fault of mine where the jury now knows that at least for some period of time, my client was in jail and communicating with family, and she did use the phrase calls with an S to indicate there were multiple calls, although she didn't say how many or for how long, and I concede that. So we would, and also the case of State versus Atkin, Atkin, 135 P. 3rd 894. Again, there's a quote, "It may be prejudicial in certain cases." Full disclosure, both of these cases, the court did not find sufficient prejudice to overturn the call the court made in the moment. I think actually Bernejo may have been not, that they weren't, they were challenging whether the lawyer was ineffective, I think, for failing to make a mistrial objection. if I'm not mistaken. I think that was Bernejo. So I'm not even sure the judge made a call on that case, but I do believe on Atkin they did. So based on the authority, the recognition that it can bring prejudice, based on the fact that this case did happen so long ago, so the jury would put 2 and 2 together and realize my client's been in jail the whole time, possibly. It's an inference that could be made. We did move for mistrial. I will state for the record, the court did provide a special instruction, limiting instruction, warning the jury not to consider that. That's one of those, difficulties because it does then again highlight that comment was made, but we were trying to do in the moment the least amount of damage going forward. I did agree to that instruction being made. I did not object to it because at that point I felt like something needed to be addressed. But that was the basis of the motion, and that's all the record we need to make.
Okay. Anything further, Mr. Bloodworth? I think I have this firmly in hand.
Yes, Your Honor, the state rests on the record that we made at the sidebar.
Okay, very good. The issue before the court is a motion for mistrial made by defendant following Ms. Gibson's reference to jail calls, quote unquote, during her cross-examination. The court finds that that statement, while improper, was not intentionally elicited by either party. It was inadvertent. It was made in passing. It was a short, quick reference. It is relatively innocuous in light of both the volume of testimony that the jury will hear in this case over the course of 5 weeks. It is relatively innocuous in light of the fact that this is a homicide trial, and so it would not come as a surprise to jurors that the defendant in a homicide trial may have been in custody at some point in the case. And moreover, the court gave a curative instruction that specifically instructed the jury not to consider that comment and not to speculate about whether defendant was or is in custody at any time in this case. Based upon those findings, the court finds that a mistrial is not required. Defendant's motion is respectfully denied. Anything further on that, Mr. Bloodworth?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay. Ms. Shervinack, anything else before we invite the jury in?
No, Judge.
Ms. Lewis? Ms. Nestor? Okay.
All right, I'll say this about the juror. I understand why the defense might have an issue, right? At the end of the day, the jury is supposed to decide the verdict based on only the evidence presented in the courtroom. And if you have had a business transaction with a person, whether good or bad, is it possible that there might be a bias there? Meaning, nothing that just. If you're a defense attorney, you'd rather be safe than sorry. And that's why they ask for, that's why they're going to do it. Plus, once again, nobody, if Kouri is found guilty, an attorney doesn't want her to be granted a retrial based on ineffective assistance of counsel. They'd rather have her be given a retrial because there's new evidence that shows her innocence, or not guilt, I should say, or there was an error during trial that was so egregious that she fundamentally did not get her Sixth Amendment. Her Sixth Amendment right was fundamentally violated, and so she did not get a fair trial. That's what if there's going to be an appeal, they don't want it to be because they didn't do a good job. Do you know what I mean? All right, here we go. Or a new trial, what'd I say? If there's going to be a new trial, they don't want it because they were ineffective.
Ready for the jury.
And like what Neat said, also additionally with the mistrial, they had to ask. They had to. They don't want, should she be found guilty? We're not there yet, but should she be found guilty, they don't want her getting a new trial because they were ineffective. And I think that they're ineffective. I think, okay, when I say ineffective assistance of counsel, it's because they don't do what they're supposed to do. Or, which this is an interesting double-edged sword. I'll give you a better example. Okay, I'm not going to use the West Memphis 3. A better example would be Brendan Dassey. Brendan Dassey's trial attorney allowed him to speak to the prosecutor and investigators without him being present. He wasn't there to protect his client. Regardless of whether you, and we're not going to talk about it, not now anyway, regardless of whether you think Brendan Dassey is guilty or innocent, the fact of the matter is it is his attorney's job to protect his client, and therefore he should never have given permission for them to speak to him without him being present. And that is a clear, because everything that he said in that in that interview and that statement was used against him in court, which is, that's why he was ineffective. Now, I think what you guys are talking about is how effective or ineffective are they being in this case for the jury's benefit? Are they proving any points? Are they
Please, thank you.
taking any wind out of the sails of the prosecution's case? And I think that in that, under those
have a seat.
circumstances, they have not been
Ms. Shermack, the
effective.
state's next witness.
They have
please.
been, in fact,
Detective Jeff
ineffective.
O'Driscoll, please.
Detective, let's get you sworn in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank you. Have a seat.
That's who he is. That who he is? Is he the guy that's been sitting in the
If you could state your name and spell your last name, please.
Detective Jeff O'Driscoll, O''DRI.
I think he's been sitting in the courtroom this whole time.
Where do you work?
Summit County Sheriff's Office.
How long have you worked there?
10 years.
What's your assignment with the sheriff's office?
I am a detective in the Major Crimes Investigation Unit.
During your investigation of this case, did you seize a cell phone belonging to Miss Carmen Lauber?
Yes, I did.
Was that in April of 2023?
Yes, it was.
Was that a black Samsung phone?
Yes.
Was the phone number on that phone ending 6127?
I believe so, yes.
Did you book that phone into evidence at the Summit County Sheriff's Office?
I think it was collected by crime scene technicians on the scene and they booked it into evidence.
Did you later retrieve that phone from evidence and with the help of Miss Chelsea Gibson download that phone?
Yes.
Was that done using the Celebrate software?
Yes, it was.
Those are all my questions for you.
Just to make very clear, good afternoon, sir.
Good afternoon, Ms.
You are the O'Driscoll, that's the chief investigator in this case, right?
Yes, ma'am.
Okay, that's all I have for now, Your Honor. Thank you.
May this witness step down, Ms. Shermack?
For now, please.
Yeah, okay, very good. The state's next witness, please.
Chris Kotridemus.
Sir, if you'd step in front of Brittany, we'll get you sworn in.
Please raise your hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Right.
Thank you. Have a seat.
Please proceed.
Sir, if you could state your name and spell your last name, please.
Sure, it's Chris Kotrodimos, Kotrodimos.
Let's go through your employment background. Where are you currently working?
I currently own my own business. I own a company called M20 Solutions.
What's that company?
We do investigations, training, and consulting for prosecutors, defense teams, and law enforcement.
Is part of that business focused on digital forensics?
Yes.
Prior to that, where did you work?
I worked in law enforcement. I started my career in North Carolina with the Raleigh Police Department. I worked there until 2003. I took a position with the Salt Lake City Police Department, where I worked there until 2017. My last 5 years at Salt Lake City were spent in the homicide unit. In 2017, I took a position with the Salt Lake County District Attorney's Office as an investigator in the homicide unit and worked there for just shy of 6 years until my retirement in 2022.
And that's when you started your own business?
Yes.
Were you asked to analyze phone downloads and phone records for this case?
Yes.
Were you asked to do that process, look at the phone downloads and the phone records for 3 phones belonging to Kouri Richins?
Yes.
1 phone belonging to Eric Richins?
Yes.
Phone belonging to Carmen Lauber?
Yes.
A phone belonging to Josh Grossman?
Yes.
And phone records related to Robert Crozier?
Yes.
Let's talk a little bit about your qualifications. What type of specific education or training have you received to be able to analyze all of this phone data?
Sure. As it relates to this case, I've taken some formal training. Of course, once you get the formal training, then you get a lot of your experience in the field, in practical experience using that training. I'm a Cellbrite certified operator course. I took that. I took the Cellbrite certified physical analyzer course as well. And then from the call detail records standpoint, I am certified and took a course in, it's called TRAX. It's owned by LexisNexis. It's a location and data analysis program for call detail records and geolocation.
Have you testified before as an expert in digital forensics?
Yes.
How many times?
At least a dozen times in major cases.
And have you testified for prosecution and defense in those cases?
Yes.
How many phones have you done analysis for in your time doing this work?
Phones, hundreds, and call detail records, I'm probably over 1,000.
Have you done downloads yourself?
I have. Yes.
For other cases?
I have.
So let's start, we'll treat it like a funnel. We'll start big picture. Let's talk about digital forensics. What is digital forensics?
The best and easiest way to describe it is the analysis of electronic devices. As it relates to this case, and my specialty is mostly phones and some computers.
So let's talk about specialties within digital forensics. What is, you mentioned that you're certified Cellbrite analyzer user
Yes.
or certified
Yes.
in that program. What is Cellbrite?
Cellbrite, they have several products, but generally what they do is they provide extraction tools to extract data from devices, and then they also provide analysis tools so that you can analyze then those readable files.
You mentioned call detail records. Is there an acronym we refer to those in shorthand?
Yes, CDR.
What is a CDR?
So a call detail record or a CDR is exactly what it sounds like pretty much, okay? It's a record from your carrier, from your cell carrier like Verizon or AT&T. And what it is it is a record of all your call details, so your incoming and outgoing calls, texts, data sessions, things of that nature.
You mentioned location analysis. How do you perform something like location analysis using cell phone data or CDR data?
Yeah, so You can map both, but prevalence is call detail records. So law enforcement can obtain call detail records that include location data with them. And location data is essentially, the carrier reports and maintains a record during their normal course of business, which towers you're using, where that tower is located, and what antenna or sector of the tower that you're utilizing for that communication.
When you're analyzing phone data, what are the two main sources of that information?
Oh, so like for phone data, like in general?
Yeah, when you analyzed phones for this case, what were the two main sources of the data?
So the phones themselves, which is the content of the device, and then the call detail records, which are the communication records associated with those devices.
So when we're talking about call detail records, I think most people understand the phone contents. That comes from the actual device, correct?
Correct.
And the call detail records, you said they were stored by the carrier. Is that correct?
Correct.
And the call detail records, would those be located on anyone's device, or are those solely maintained by AT&T, Verizon, T-Mobile?
Yeah, the records themselves are maintained by the carrier.
And what is contained in a call detail record?
There's a lot of information in there. There is typically a timestamp, so there's a date and a time that the communication occurred, amongst whom the communication took place, between which carrier or which numbers the communication took place. So, which phone numbers, whether it's incoming or outgoing, the duration if it's a phone call, and then of course the tower information, the tower location information.
Would a CDR record contain, for example, it would say a text is incoming or outgoing? Would any of the content of those messages be in the call detail record?
No, not in a call detail record.
How do you start, or how do you analyze the contents of a phone? What do you use to do that?
So in this case, I used Cellbrite Physical Analyzer.
And how do you use Cellbrite Physical Analyzer? What does that provide you to allow you to analyze the contents?
So Cellbrite Physical Analyzer is a software package, and what it does is it allows you to analyze readable files from the extraction. So the phone is downloaded, a readable file is created, you load that readable file into Analyzer, and then you can analyze those results.
How often is, are there other programs besides Cellbrite that can perform that function?
Yes.
Is Cellbrite the most commonly used one?
Yes.
Why is that?
It's very popular because it's got a very user-friendly interface. It's widely known. It's widely regarded. Analysts and people that do extractions and downloads and have learned that they can rely on the results of those. They're pretty good, and so it's commonplace in this industry, particularly in law enforcement.
So now you testified that you've done downloads yourself of some phones.
Yes.
Can the person doing the download, extracting that raw data from a phone, can they change the contents of the phone when downloading it?
No.
Can they manipulate it in any way when it's going from the raw data into the Cellbrite reader format?
No, I don't know of a way to do that.
Why might a cell phone be downloaded or extracted more than once?
Usually it's different products are being applied to the phone. There are software updates, but more importantly, there's different products that might be available to obtain more data versus the other, particularly.
When you receive the download report from the phone in the readable format, what is contained in that report?
In the report is going to be all the system files. So there's going to be, most importantly, is the calls, texts, the web history. There can be biometrics. There can be like activity, movement of the device, biometric information, web searches. There's pretty much everything that is contained in a phone that a user might utilize, or it would be available in that download.
Can a download report show if there have been things deleted off of the phone?
Yes.
How does it show that?
Yeah. In Physical Analyzer, if the extraction software recovers something from a database that has been set for for deletion, it can find that and then repopulate it into the phone as to where actually into the report for where it belongs. And when it does that, in the program, it signifies that with like a small red X in a column next to it to let you know that it had been previously deleted from the device as an active user, or by the active, the active file. But the software has been able to go in, find it in the database, and repopulate it.
So if a user deletes an item, it might still be stored on the phone that can be pulled by that report.
Correct. They may not be able to see it and think it's gone, but it may still be within a database that can be retrieved and repopulated.
So basically, the lesson here, ladies and gentlemen, is A, either don't do a crime, right? B, if you do crime, don't take your phone. Or C, if you do a crime and you do take your phone because you ignored A and B, then the only solution you have is to destroy the phone. Got it. Thank you, sir. Listen, I know that they have to do this for the jury, but we're ready for those damn texts. Let's go.
Now, is that possible for all items that a user deletes?
No.
Why not?
Some of those deletions are system files, and so they're maintained in the background. The average user would not, or probably be able to, delete system files. They literally run the phone.
So if I'm a common user of a phone and I delete a photo, how long would it be kind of in the background of that phone and able to be downloaded by this report before it's gone forever?
Right. Well, it kind of varies, and it varies by, there's a lot of variation there. But typically, when an item like an image is deleted, the image itself, that process, the original, like if it was sent to you or whatever, and you deleted it, it would be gone from your view in the phone, but it would be in a deletion file. And so that deletion file eventually has to make room for more deletions, so that it pushes deleted files out to make room for more deletions, so that it can so it can refill it. It only has so much room, so it has to purge that at some point. And that time can vary. More deletions are going to make that process typically happen more rapidly than less.
So if items have been deleted by a user and that phone gets downloaded in maybe that sweet spot where it's still somewhere in the background of the phone,
right,
that could be in the report.
It could be.
But if you miss that window, and then the item is gone for good and can't be found in one of those extraction reports.
Pretty much. Once it's deleted from the system file, it's a process called a vacuum. Once it's vacuumed out and those files are reduced, it's essentially, you're probably not going to find it.
Now, if a user deletes a text from a phone, from their own phone, does that affect how the text message would show up on the receiving end?
No.
Shifting over to the CDR, the call detail records, you kind of described what that is, and that it's stored by the cell phone carrier. How long is that data stored by the different major cell phone carriers?
They're all different, so they maintain their records for varying amounts of time. Verizon typically will keep call detail records for 18 months to 24 months, but they will only keep the associated location data for about a year. Whereas AT&T And T-Mobile will keep that information for a much longer time.
Now, because this data is maintained or kept by, AT&T or Verizon, can a user access that information?
No, those are business records maintained by the carrier.
Okay, I feel like we have a good groundwork now, and I want to turn your attention to what you
I hope
did,
so.
what you did in this case.
Okay.
When were you brought on to work on this case?
I came on in May of 2023.
And in general, what were you asked to do for your part in this case?
Analyze phone downloads and analyze call detail records for pertinent information related to the case.
And so you analyzed phone downloads for this case, and you talked about the process for doing that. Did you perform any of the downloads for the phones, in this case, yourself?
The downloads, no.
And in viewing the download reports for the phones you analyzed, did you learn who the phone belonged to?
Yes.
How do you do that?
Well, besides the record or file being designated as belonging to that person, when you open the physical analyzer report, it gives details about the phone number, the IMEI number for the phone, and whatnot, and that can be matched to the user, whomever was using it at the relevant time.
As you analyzed phones for this case, did you generally become familiar with the people involved?
Yes.
Did you become familiar with what they look like?
Yes.
How did you become familiar with what these people look like?
Law enforcement shared that information with me, but in most instances, when I looked into the phone downloads, there are pictures of those people inside those phones doing various things, hanging out with family or, contact photos, that type of thing.
I first want to turn your attention to Eric Richins' phone. Did you do an analysis of Eric Richins' phone?
Yes.
And was that a phone with the number 801-792-9317?
Yes.
Did you receive a download report from the Summit County Sheriff's Office for that phone?
Yes.
And was that download performed by Changi Entau and Marcos Garicachia?
I believe so.
When you reviewed the report for Eric Richins' phone, did you find any evidence of mass deletions on his phone?
In Eric's phone, mass deletions, no.
How would you be able to tell if somebody had made batch or mass deletions from their phone?
Usually, if it's not evident in the actual phone download, whereas you can actually see the software has reported that those items were found as deleted and recovered. Outside of that, you would compare it to other types of evidence, such as like the call detail records.
So how would you be able to tell if there were deletions when comparing the phone to the call detail records?
It's basic. You just take the call detail record and you look and you see who that person was communicating with through their call detail record, and then you would be able to verify if those communications were maintained in the call logs on the phone themselves. So if I called you 5 times today, it would show in my call detail record, but if you downloaded my phone, it would also show in my call log that I called you 5 times today and what time of day and how long our phone calls were.
Did you review text message conversations from Eric Richins' phone?
Yes.
And in addition, did you review device activity data?
Yes.
You mentioned biometric data. What type of biometric data can you recover from a phone or review?
Right. It's kind of hand in hand with the activity report that you just mentioned. When a device moves or a connected device moves, it reports that movement to the device, and it's found in that activity sensor report portion of the download.
Did you look at Eric Richins' phones for evidence of THC gummy use?
Yes.
And did you find text messages between Eric Richins and Kouri Richins as it related to THC gummy use?
Yes.
Was that 3 conversations?
It was.
Okay. Was that 1 conversation in November of 2021?
Yes.
and 2 conversations in January of 2022.
Yes.
Scott, if we could show the witness 2-118D. Is it on your screen?
It's not. I've got
Okay.
a desktop.
You have Blue Bear Law showing. Oh, my apologies. That's okay. 1 second. Counsel.
Is this the conversation you referenced from November of 2021?
You may need Scott to zoom in. It's pretty small.
Oh,
It is. I'm wearing my.
there we go.
Yeah, there it is. Yeah, better. Thanks, Scott. Yes, this is a November of 2021 conversation.
And that's between Kouri Richins and Eric Richins.
Yes.
Scott, if you could show the witness 2-119D, please. Is this a conversation between Eric Richins and Kouri Richins in January of 2022?
It is.
Thank you. And Scott, if you could show the witness 2-124D. And is this another conversation from January of 2022 from Eric Richins to Kouri Richins?
It is.
Did you also analyze Eric Richins' phone for information about illicit drug use?
Yes.
Did you find anything in Eric Richins' phone about illicit drug use?
No, outside THC, I didn't find anything.
Any communications on Eric Richins' phone about buying drugs?
No.
Now I want to talk about Kouri Richins' phones. Did you analyze 3 phones that belonged to Kouri Richins
I
for
did.
this case?
I did, yes.
Scott, if you could put up 3-37D, please. Do you recognize this?
I do.
What is it?
This is an exhibit that represents the 3 phones that you just mentioned that were being used by Ms. Richins that are relevant to this case.
Did you help create this exhibit?
I did.
I'm going to move to admit 337D.
No objection. Okay. States 3-37D is admitted.
And publish, please.
Done.
Okay. I have a pink pointer that I'm going to try to use.
All right.
What do you think, Scott? Okay. Let's start at the top.
All right.
What phone is at the top of this exhibit?
Okay, so the phone at the top of the exhibit on the left-hand side is Ms. Richins' white iPhone, and the 2 numbers that are there, next to the 1 and the 2, those represent the phone numbers that were being used on that device during the time of September 2020 to April of 2022.
What do those dates represent?
That's the duration of the time that phone was being utilized.
So you mentioned for Kouri Richins' white iPhone that there were 2 numbers on that phone. What number were you able to determine was maybe the primary or most used number for that phone?
Right, so the number ending in 1987 is going to be the primary number. That is the carrier subscriber number through Verizon that phone was utilizing. And then the 1152 number is a VoIP number that was being used on that device as well.
So you said VoIP number, but tell the jury, how do you get 2 phone numbers on 1 phone?
You just use an app.
Okay. How is, in this case, the number 1152, how is that different than what you called the subscriber number, the 1987? How is it different?
Right, so that number, a VoIP number, it uses the internet to make calls, make and receive calls, make and receive texts. You can use that number like you would your normal carrier number. The difference is it uses data, and so It typically doesn't show up on your call detail records when you use it.
Did you view a download from Kouri Richins' white iPhone?
I did.
And that came from the Summit County Sheriff's Office?
It did.
And that download was performed by Cheney Engtao and another download by Marcos Gary Cuchilla?
I believe so, yes.
Did that download contain text messages, call logs, web searches, things like that?
Yes.
In addition to that, were you also able to view what we were calling activity data or device sensor data for that phone?
Yes.
When you did the analysis for that white iPhone, was there evidence of deletions?
Yes.
Was there evidence of text message deletions?
Yes.
Evidence of call log deletions?
Yes.
Describe what time frame you were able to recognize those deletions happening.
The time frame essentially for that device is mid-March. So specifically as it relates to some of the other items I looked at related to this case, we're looking basically January 1st through middle of March 2022.
What was missing from that phone for January 2022, February 2022, and March 2022?
Hundreds of text messages at least. They were also missing most of the web history artifacts in that device.
Call histories as well?
Call logs, etc.
So turning your attention to the middle phone here, what are the dates for the use of that phone?
April 14th, 2022 to May 8th, 2023.
Now I noticed that silver iPhone has the same number as the white iPhone. How did that occur?
So this is a new device that Ms. Richins began using on April 14th, and she basically just had her old number assigned to this new device.
Were you able to view a download for this phone?
Yes.
And that was performed by the Summit County Sheriff's Office?
Yes.
Now, comparing Kouri's silver iPhone that she began using in April of 2022 compared to the prior phone, the one that she was using leading up to that point, were there patterns of deletions in this phone similar to the white iPhone?
There were some deletions noted, but not in the same manner as the previous phone, no.
What do you mean not in the same manner?
Meaning there were not big chunks of hundreds of text missing from the device that I noted, compared to the new phone did not have that type of deletion in it.
So now let's talk about the third phone on this exhibit. It says Kouri Richins' blue iPhone. Did you also view an extraction for this phone?
I did.
Or I guess extraction and download. I'm using them
Download.
interchangeably. Is that
So
okay?
do I. That's fine.
They're the same thing.
Yeah.
And that download came from the Summit County Sheriff's Office?
Yes.
Now, similar questions about the blue iPhone. It seems that the date ranges for that are the same as the silver iPhone. Is that correct?
Correct.
So, based on your analysis, Kouri Richins was using the blue iPhone and the silver iPhone at the same time.
Correct.
Same question for the blue iPhone. Were there mass deletions on the blue iPhone when comparing it to what you looked at for the white iPhone?
No.
Now, you did an analysis of a phone belonging to Carmen Lauber, is that correct?
Correct.
And that's the phone with the number ending 6127?
Yes.
Did you analyze CDR data for Carmen Lauber's phone?
I did.
And did you view an extraction or a download for that phone?
Yes.
And that came from the Summit County Sheriff's Office?
Yes.
On Carmen Lauber's phone, were you able to tell if there were deletions on that phone?
Yes.
What were you able to note about items being deleted?
Essentially in the same manner as with Ms. Richins' original phone. when comparing Ms. Lauber's call detail records, there were hundreds of texts and dozens of calls contained in those call detail records for that period of time, but they were no longer contained inside the device. Like there was pretty much all of it was gone.
Did you also look at call detail records for Robert Crozier's phone?
Yes.
And was that for a phone with a number ending 0540?
Yes.
All right, turning your attention to Robert Josh Grossman, did you analyze a download for a phone belonging to that person?
Yes.
And that download was given to you by the Summit County Sheriff's Office.
Yes.
One download that was performed by Marcos Gary Cachia. Is
Yes.
that correct?
Yes.
And that phone is had two different numbers associated with it, 1260 and then 0904.
Correct.
When looking at all of these different phone downloads, did you analyze communications between Eric Richins and Kouri Richins?
Yes.
Scott, if you could show Mr. Kotradimus Exhibit 2-3D, please. Just zoom in a little bit so he can recognize it. Is this a message between Kouri Richins and Eric Richins from December of 2020?
Yes, it is.
Scott, if you could show the witness Exhibit 2-5D. Is this another message between Kouri Richins and Eric Richins from June of 2021?
Yes.
Scott, if you could show the witness Exhibit 2-17D. Is this a text message between Eric Richins and Kouri Richins in January of 2022?
Yes. Yes, it is.
Okay, before we jump into communications between some of these other parties, I want to see if you have analyzed these messages as well. Scott, if you could show the witness Exhibit 2-121. Do you recognize this message as a text message thread that you analyzed from Kouri Richins' phone from December of 2022?
Yes.
Scott, if you could show the witness 2-112. Similar question, do you recognize this as a text message from Kouri Richins' phone that you analyzed from February of 2023?
Yes.
And Exhibit 2-113. Do you recognize this message as a text thread with Kouri Richins from March of 2023?
Yes.
And Scott, 2-14, please. Do you recognize this as a message from Kouri Richins' phone from March of 2023?
Yes.
Thank you, Scott. Did you analyze communications between Kouri Richins and, I know he goes by Josh, but Robert Josh Grossman?
Yes.
Did they communicate as far back as 2020
They did. Yes.
and through October of 2022?
Yes.
What were the typical volume of calls and texts between Kouri Richins and Josh Grossman?
Particularly from November of 21, which was essentially when the 1152 number showed up on his phone, daily, with a few exceptions.
Now, Scott, if you could put up 337D again, please, for the jury as well.
One moment.
Now, you mentioned that the 1152 number showed up on Josh Grossman's phone. What number did Kouri Richins and Josh Grossman, from Kouri Richins' side, what number did she use